All right, so my name's Jack Maguire. I'm one of the directors of the Red Union Support Group. We are the umbrella organisation that looks after the Nurses Professional Association of Australia, the Teachers Professional Association of Australia, Professional Drivers Association of Australia, and the Australian Medical Professional Society. Look after nurses, teachers, drivers, and doctors, as well as all ancillary staff as well. So AMPS, they did say they wanted to be a union run by doctors for everyone. So if you are even interstate, I know we're based in Queensland here, but if you're an interstate wardie or an allied health professional or an acupuncturist, AMPS said that they would like to be the home for you. So we probably likely going to be focusing on Queensland, unless there's any other questions in the chat, given the imminent deadline coming up. There's been some good news over the past couple of days, I think, that should give us some cause for resolve. So with me here, I've got Dr. Tracy Watts, who is a vet, but very capable, done plenty of scientific research and is totally aware of how to research science and is coordinating that and leading our volunteer group who are outside. And on the other end here, I've got Miles Heffernan, who is an industrial advocate and a total genius in this space. And many of your letters and requests for risk assessments are being escalated to Miles and his team, and you are in absolutely capable hands there. So thanks for joining us, Miles. And I guess I'll just from the top reiterate, if there's new people joining who haven't already sent off requests for risk assessments, I'll just very quickly explain our steps. If you go to any one of our websites, and I know there may be even police joining us today, that's great. Thanks for joining in. If you go to one of our websites, you can go to www.redunion.com.au, and it has a list of our unions. Just pick one. If you go to stage, there's a notification at the top of the website, I believe, WHS concerns. Click on that and it'll outline stage 1, stage 2, stage 3. And the first stage is sending off a request to your line manager. It's not too late, even if the deadline is imminent. It's not too late. Get that request off immediately to your line manager, asking to see a risk assessment for how they have risk assessed COVID-19 on the workforce in your area. So it should be your ward or your police station, as granular as that. And if they haven't provided it, if they can't provide it, well, that's contrary to what the Workplace Health and Safety Act says. So they must be able to provide it. And if they don't provide it, escalate it, the request to your manager's manager. And even if you need to, your manager's manager's manager. And that process will be stepped out in the stage 3, 4, and so on. So please jump on the train as quickly as possible because time is running out. If you can't get through to us, the process should be fairly self-explanatory on the website. So you may need to use a little bit of intuition. But Miles, I might throw to you just to explain a little bit of happenings, what's happened recently in the Fair Work Commission, and where we're heading with this.
Well, good morning, everyone, and thanks for taking the time. And I appreciate that most of you are on this video because you're concerned about making sure that you're safe. And so what we want to talk about are the steps that have been taken already, and quickly touching on two very, very important developments from yesterday. One of the fundamental requirements of safety is that it deals with risk in an escalating way. That is that a boss, when putting in risk mitigation processes, must do so in a manner that starts with the number one being to engineer it out, and the last one being personal protective equipment, such as a helmet. Now, what happened yesterday was that the TGA approved rapid antigen testing. What that means is that within half an hour of the test, your employer would know your COVID status. That would mean that you could in essence, have COVID engineered out of your workplace through the correct testing, as opposed to a jab, which in the this particular vaccine will potentially reduce the risk of COVID, but will not engineer it out. And that fundamental question of safety is bothering a number of members, and rightfully so. So for the last 2 weeks, the various unions that are represented here today have been asking for those risk assessments. And if you look at what happened from last Monday, there was pretty much a brush off. And as of yesterday, the first of them started to filter through, and I see a commenter there just said that they got that risk assessment. A risk assessment has to follow a very specific process. That risk assessment it will need to follow an Australian standard unless the employer has a very good reason not to. As a consequence of that, we have not yet seen a single risk assessment that is consistent with the Australian standard on how to rate risk. Now, risk rating is critical. That is, even banks use risk assessments to work out if they're going to lend you money. It follows a scientific methodology. Once that component is dealt with, the second component is consultation. That is, that even when discussing risk, the employer must consult with the workers. That is not with a particular worker, but with the workers and at a business unit level. Now, we've not seen a single example of where that has occurred. And as a consequence, the first step has been to ask the employer, what is this risk assessment that sits behind the health directive? Because even though there is a health directive that is being empowered by the hospital and health boards, that legislation specifically requires that the health directive is read in conjunction with other law. That is, that other law is in priority. Now, what we've seen is that the health directive appears in all the circumstances to have been issued, certainly without an on-the-ground risk assessment at a business unit level. And from best we can tell, there doesn't even appear to be a global risk assessment. What we're concerned about is how the organisation is assessing risk. And when we've asked for that information, we haven't got it. Now, hundreds and hundreds of letters have gone to the various hospital boards in the last week. And as I said, most of those were knocked out saying we don't need to even show it to you. Finally, there has been some movement in the last couple of days, which is great. As if you are in receipt of a risk assessment, please do pass it on to your relevant union so that we can help you and get some support. Now, the second component, though, is that even if there is a risk assessment, one of the things we have to look at is the best alternatives, that is to engineer out the risk. And with rapid antigen testing being now approved by the TGA, we hold very, very grave concerns that engineered risk is not being considered as the first and foremost. And a special hat tip to Tracy, who has also been facilitating and working with multiple senior scientists and senior clinicians and senior independent experts to trawl the data. That said, unfortunately, the information we've been getting from the various hospital boards and from Queensland Health hasn't kept Tracy too busy yet at a scientific assessment level. And we want it to, because we're ready, willing and able. And all of you are ready, willing and able to work. And someone just made a note, is this financial blackmail? Well, what I will say is we didn't pick the deadline. Out of nowhere, your employer on the 11th said that on the 1st of October at 12:01, these are the new rules. That happens to be coincidental with the end of the month. What makes the end of the month the magic day where the risk profile changes? As a consequence of that, there's been multiple fights. We understand that a Supreme Court judicial review has already been filed, and your union is briefing both senior and junior counsel to also consider those very same issues to see whether the Supreme Court agrees. But fundamentally, irrespective of those other broader legal strategies, your personal safety and your personal right to work are not to be run roughshod over. And what we're most disappointed by is that the requests for risk assessments have been so slow, I guess, not responded to, yet we've got a deadline in a day and a half. How is that possible? So our job is to make sure that you've exercised your rights. Now, if you're not genuinely concerned about your risk to health and safety and no consultation will change, then this process is absolutely not for you. This has got to be for people in the workplace who are concerned that an arbitrary direction has been done in isolation of a risk assessment. And in the perfect world, some of you may look at that risk assessment and go, well, I'm now happy, the risk assessment suits me, and that you'll roll your sleeve up and get a jab. And others may have more questions based on your specific situations, such as if you're of a childbearing age, such as if you are built like me, and therefore there is some evidence that certain jabs have an impact where your heart is enlarged. Who knows? The whole point is that Tracy then can facilitate those risk assessments once we've got them and interact with some of the best scientists in the world, which has been her job so far. Outside of that, a critical decision came out of the Fair Work Commission. It was a dissent decision. What that means is that 2 commissioners said yes and 1 said no, but this commissioner was exceptionally strong that forced jabs are inconsistent with fundamental human rights. She also went on, as a Deputy President Dean, went on to express grave concern that an employer was not conducting the very risk assessments that we are talking about now, and that a total you must mandatory jab, her exact words were that it was lazy. This is very important because it means that very senior minds are looking at this stuff. Very senior judicial and quasi-judicial figures are turning to their mind to the very issues that you guys are being exposed to, and that's critical. All we want to do is assess the risk. And if your boss is being delayed, why should you not be paid while you're lawfully going through that process? Just because they picked an arbitrary deadline does not make it fair, right, or potentially lawful if you follow the good faith steps that your unions are recommending. So Jack, that's the overview, unless you wanted me to dig further, and then I'll throw to you.
No, that's great. I just wanted to reiterate again, you know, some people are worried that how many are there in the workforce. It was today reported in the Australian that it was 11% of Queensland Health workforce remains unvaccinated. This is the Australian reporting. Yesterday, I was told by the Courier Mail that there was 10,000 people that hadn't been vaccinated or uploaded their vaccination status. So I don't know where they're getting their stats from. Our estimates is it's a hell of a lot more than that. We did a survey of 2,000 nurses, 56% said that they were unvaccinated. Now, I know that's probably not likely to be the case across all nurses, but there was also a Forbes magazine article that said over 50% of nurses in the US hadn't been vaccinated. So there are a significant amount of people in Queensland Health who haven't been. And I think one of the concerns too is I don't think Queensland Health knows how many of their employees have been vaccinated yet, because there are still people that haven't uploaded their status yet, and they're only trying to do this rushed at the last minute. And I guess I'd just like to read out a quote of Angus, our secretary in the Australian today. Nurses Professional Association Queensland Secretary Angus Hopkinson Pearson said the department would be liable for any adverse patient outcomes from a shortfall in staff. The NPAQ hold grave workplace health and safety concerns for Queensland health workers. He said, corners have been cut, and this rushed mandate deadline will leave thousands of good nurses who are ready, willing and able to work locked outside of facilities, while inside wards will be closed due to staff shortages. And I think that's exactly where we're at the moment. We have a whole bunch of nurses who really just want to care for patients. And Dr. John Wakefield has said, that he's going to lock people out and stand them down without leave. It's, I think it's atrocious. And I think there is a turning point in the media. Even this morning, I was on 4BC Neil Breen, and Angus was on there, our secretary, 2 weeks earlier. 2 weeks earlier, Angus was told that he was representing anti-vaxxers and got stuck into him. Today, Neil was having to give us a fair hearing, and we were pretty fired up, and we gave Dr. John Wakefield both barrels, and I think Neil was quite receptive to it. So, as Miles was saying, the Fair Work Commission has I think, put down quite a considered, logical dissenting opinion when it comes to this particular issue. As long as we're not seen as anti-vaxxers, which they will, dismiss out of hand, and as long as we are seen as what we really are, which is having genuine concerns about workplace health and safety, I think they will grapple with these very real issues that we've raised. Plus, the media seems to be starting to give us a hearing, and they understand the gravity of what may be coming at the end of the week. So, please.
And flowing from that is that when we started this process, we were getting the calls that we were representing anti-vaxxers, and that what should we kill granny while we consult, and really aggressive language like that. And the decision from the Fair Work Commission, which doesn't impact on state government employees, also made it clear that it's not science if it's arbitrary imposed and there's no discussions and assessments. And so if you are being targeted or name called because you are genuinely concerned about your health and safety, we get it. We're in the same boat. We're here to support you. And it's a tactic. And what was really interesting was Deputy President Dean called that out for what it was yesterday as a marginalisation process, and these are fair questions to assess risk as well. So the areas of human rights that or the areas of law that we are looking at to review at a Supreme Court, which has not been finalised, does include though questions around privacy. And whether or not to upload the material. And I see some questions already coming up around that. We're getting a final position from council today on that. And so we don't have to upload the documents until tomorrow for those of you. So we will have a very specific position for you by close of business today, or at the very latest, first up tomorrow. Appreciate that's late, but those privacy issues are real and as it's in the direction that you must. And there is a threat that if you don't follow the direction that you may find yourself in other trouble. Which leads to the final issue I wanted to highlight, which was there are ways and means to go about things. For example, if your boss tells you not to return to your worksite, don't march to the worksite, say, I'm here, ready, willing and able to work. You may be not following a lawful direction from your employer, not anything to do with now vaccines or direction or health employment directives, but more simple rules that the boss does control the place. And so we must be rationally going into this process. But we are mindful of your rights to privacy. We are mindful separately to human rights around being forced to have experimental treatment. We are, and in that regard, Margaret Gilbert, the president, wrote to Dr. Wakefield asking for the reasons for his decision to make the directive. That's a statutory process as part of the Judicial Review Act and ought to be done in advance. We notice we haven't got that yet. Now he does have 28 days. We have asked for a speedier timeframe, given that it's his deadline that we're working with. And as a consequence of that, we're pressing for that as well. And finally, a document went out from Dr. Wakefield yesterday, which we take as a softening of a position with relation to the hard and fast deadline of the 1st of October. And but each case will turn on its own merits. So if you have not completed your if you are not applying for an exemption, you still need to get advice from your union.
Righto, let's do some quick fire questions. Should we put in an exemption? There's a couple of other questions about various circumstances of when people should put an exemption. Miles, should people put in an exemption?
Of course, if you genuinely qualify for an exemption and you meet the criteria, you should absolutely put in an application for an exemption. There's obviously two. There's a medical exemption or there's a faith-based exemption. If it is genuinely within your doctrines and beliefs, the tenets of your religion, and your pastor or your rabbi or your other spiritual leader signs off on it, then that's very important to get that processed. Your employer has said for any exemption, it will take them up to a month to individually engage with it. And you must have that application in prior to tomorrow. So if you do have an exemption, you ought to get it in prior to tomorrow, so prior to midnight. So yes, absolutely. If you qualify, you are counselled very cautiously against trying to make up an exemption or to ask your doctor to provide something that is not real. Your doctor is highly unlikely to do it. We're seeing a very strict interpretation from clinicians that are being asked. And secondly, if it's not something that your religion has spoken about, you would obviously be prepared that your employer may challenge you on that.
And I'll just say too, just speaking on behalf of the Australian Medical Professionals Society, they being doctors were written to by AHPRA at the start of the year, saying that if they deviate from the government line on any of this stuff, including COVID jabs, they risk facing prosecution and losing their AHPRA registration. So they have put the fear of God into them. So just keep that in the back of your mind. Miles, I've got a question here. Someone in New South Wales put in a request for the risk assessment. I'm still waiting to hear back. They're wondering whether they should fire off other letters from other people, such as AFL solicitors, around informed consent, economic distress, freedom, etc. in that position, and what should they be careful of under the Workplace Health and Safety Act?
So if AFL or other solicitors and you're engaged with those, it's obviously important that you get your legal advice from those that you've briefed, and we don't want to give you advice outside of your other representation, of course. So first and foremost, if you have legal representation, they are the best ones to advise you of your personal circumstances. But in broad terms, as well as meaningfully engaging with the work health and safety processes, if your employer is not complying, there are other provisions within that Act. But as you rightfully noted, there are also others which are in relation to both the Disability Discrimination Act and so there's causes of action potentially with the New South Wales Anti-Discrimination Board. As you've rightfully noted, there are also privacy issues. The most important component is to ventilate those issues in a way that is respectful, in good faith, and as soon as possible. And obviously each case turns on its own merits. So if you've got some specific questions, again, fill out a member support form and then they'll be actioned. I do need to stress though that with the deadline of tomorrow, nearly all resources are being placed on that deadline, and then there's another deadline in a couple of days from there. So they are, the date of where there is a problem is being used as part of the triaging process for member support inquiries. So please bear with us because there's been over 1,000 in a day.
If I have an exemption waiting to be approved, does this mean I can attend my shifts on or after the 1st of October? I believe that was dealt with in Dr. John Wakefield's directive yesterday, was it?
Yes, it was. You are required to wear a mask, and while the exemption is being considered, and a couple of other PPE requirements. But yes, if you've applied for your exemption, it's being considered, and they are using it up until the 31st of October to engage with you.
Do you need to send off a risk assessment if you are applying for a religious exemption?
The two stand they're entirely separate. So you can both have a religious exemption that you wish your employer to consider, and also be genuinely concerned about your work health and safety issues. So it would be one that if both are relevant to you, then both should be sent off.
I have been denied my leave entitlements. So I will canvass this at the start. There are another couple of questions that say they have been stood down without pay since Monday, last Monday even. There's another one here. I have been denied my leave entitlements. As per Queensland Health's Director General's statement, we can take our leave and non-service leave. I submitted a request on Monday and this was her reply. I've been advised not to process or approve any leave applications beyond 1st of October that fall outside my allowable leave FTE until further notice, and as SCN has already reached our leave threshold for the coming 3 weeks at least, I'm unable to process your leave request at this stage. Whilst you'll not be able to work without having had the first COVID-19 vaccination, you will not be able to attend work and will be booked off.
Yeah, that's it's going to be a long answer to this, and it's a brilliant question, and thank you for the detail in it. What's in essence happening here is what some might call a reverse strike, where your employer has said, I'm going to lock you out of the venue if you don't take these steps. Now, if we were to do that and say, boss, if you didn't take those steps, we're going to not show up, we would face unlawful industrial action allegations. First of all, when taking leave, it is your safety net, it is your asset, it is there for you when you need it. We are gravely concerned that leave is being proposed, your asset to be drawn down, simply because someone has made an arbitrary deadline. On the other side of that coin, though, we are mindful that you've got families and mortgages and alike, so the idea of your employer playing chicken with your money and your weekly paycheck is an incredibly confronting area. Our position, though, is that your employer, if you are meaningfully consulting through the work health and safety process or the exemption process, your employer cannot not pay you, cannot lock you out, because you are exercising various rights, all of which bring with them protections. So someone, I think, used a word earlier about it being a forced requirement or coercion, or even I think they might have even used an extortion type word or something. I'm sorry if I've got that comment wrong. We're very concerned that your weekly paycheck is being held over. So if you are a if you're a part-time or full-time employee, we would say that the absolute minimum your employer ought to pay you is your ordinary time. It might not be you get shift allowances and the likes. Now, the final part of that question is really interesting in that they are saying that you can take this leave because they've put this forced requirement, yet they are stopping you. I would love to see that correspondence, make sure, and if that's the case, that's something we can mobilise with very quickly. It's pretty rich, isn't it? It's their terms. They've put this arbitrary deadline that coincides at the end of the month. They've told you can draw down on your leave, and now they're saying they can't. All in circumstances where the Industrial Relations Act requires consent for annual leave unless your balance gets to a certain point. And so it's an incredibly serious and extraordinary development to now hear that they are going to also try and literally starve you out after making that deadline. If that's happening, we will absolutely mobilise quickly, and that's a today type function. So that commenter, please, if you could reach out and in the subject line, if you could just put leave denied, so that we can search for that, and we'll look for that email as soon as it comes in, and make sure that we can attend to it, because that's a really important development that we need to action today.
I guess you sort of just answered that question again, Miles. If I've been stood down for 2 weeks, can you still send letters? They don't seem to make sense when stood down. This seems to be those working. So I guess the response to that is sending a notification that, or they should still send off those letters.
So, well, for a start, you're not stood down. You're ready, willing, and able to work, and there's not a stoppage of work. And that's the test for stand down, right? So any employer that's characterising you being locked out of a work site as a stand down is misusing a very specific industrial term, right? And what's happened here is that your employer is preventing you from working when you're ready, willing, and able. Now, each case turns on the start, turns on your facts, I should say. However, if those of you that have been stood down as a preemptive strike, when this direction doesn't take effect until 12:01 p.m. on the 1st of October, that's a very, very serious concern. That's if you are a state government health employee. If you've been stood down in another environment, then we will need to look at those on a case by case. But the starting position is that you cannot be stood down if you are ready, willing, and able to work, and there's not a stoppage of work. So it might be that if your employer is locking you out of the work site, that might not be lawful. And absolutely, so the risk assessment said if you're concerned about your safety, because your employer has taken the preemptive strike of locking you out, and if they haven't consulted with you, that's a really aggravating factor.
There's a question here about not being able to log on to the AMPS dashboard, enable cookies, etc. I really need steps 2 and 3. What actions can I do today? Look, I'll apologise. Our website is starting to do some funny things because we're getting such a high volume. But please call the hotline today on the AMPS website, and someone will be able to help you out. But my understanding is if the cookies, etc., aren't working, there should be a fallback, which is I think called a magic link. And if you send that, it'll send you an email. And if you check your emails, you can get a link that will log you straight in without having to put in a password, etc. It'll just send it directly to your email. So hopefully that helps. And that applies to all the NPAQ, NPAA, TPAA websites as well. Do I have to supply a COVID-19 risk assessment for my area of work and for each employer in my area? Yes. I work for Queensland Health. I've completed step 3, no response this far. My line manager has encouraged me to apply for an exemption so that I can continue working for another month. What should I apply? I guess you should only apply if you believe you have a reasonable grounds for an exemption. Just because your manager wants you to turn up to work, and don't let your manager force you into fudging an exemption. That would be certainly not recommended at all, and that would put you at risk.
No, only echo, sorry, just a really important point, because the breathing space of that month is predicated on, for Queensland Health employees, that you've made an application for an exemption. Just really stressing what Jack's saying there, don't get caught into a honey trap where your boss is luring you down to say, oh, by the way, apply for that, when you know you are not going to be eligible. For example, you say you're suddenly of a faith or you're not, or you ask your doctor just to say you're contraindicated with a wink, wink, nudge, nudge kind of thing. That could get you in a lot of trouble in a month. Only apply if it's a genuine good faith exemption. There are other means to deal with it. And the clarification statement from Dr. Wakefield is just that. to clarification, and it's now put this new term on that this month's consideration is only if you've applied for an exemption. Well, that might not be the last of that. That's a really important development for those that have sought an exemption, but it doesn't close the gate for others, but we must handle it in an appropriate way.
I've received a risk assessment back from HR. I'm still going to fill in the form on your site and forward the risk assessment they gave. Basically, they say, regardless of the risk assessment, it's currently the law. Well, that's not the case. I think we've covered that question. I work in Queensland as an agency nurse, but my employer is based in Melbourne. What can I do?
Each state turns on its own facts, but that would make you a private sector employee, and so it will depend on if there is an enterprise agreement for dispute clauses, and it would depend upon the nature of work that you're in and its relationship with any Victorian directives or guidelines. So I'm sorry to give you a rounded answer there, but in the private sector, the most likely place that you could deal with it is either as a industrial dispute. But Victoria has very good human rights and equal opportunity laws. And while, again, it's only guidance, the dissent decision from Deputy President Dean yesterday did indicate that it would be a cause of action for a discrimination claim in that situation. So if the person is working in a public sector hospital at all in Victoria, there is, of course, the Victorian Charter of Human Rights as well.
If it has been passed on, your inquiry has been, so it's been passed on. So your inquiry has been referred to SCHS COVID-19 mandatory vaccination at queensland.health.queensland.gov.au by my line manager. Should I fill in a form in step 3 and send it to the line manager's manager?
There is a grievance procedure that is published on the respective websites for different employers in the state government, but it requires that you go through the local action process and escalate locally. We're surprised that the employer is diverting it elsewhere. Why we say that is that each worksite is its own business unit, but importantly, there are hospital and health boards, as you know. Now, while you're all Department of Health employees as of this financial year, each hospital has its own governance structure. So how can they delegate or refer occupational health and safety issues that are their responsibility as the party in charge of the business unit to the Department of Health at Charlotte Street? It's an interesting reasoning. We are concerned that they are not dealing with it at a local level, and as a consequence of that, please obviously let us know through the member support processes, and we'll look at those individual cases.
The DG said in the email yesterday, we have to advise our line manager in writing if we are not compliant. I'm wondering what wording we should use. I'm going to have to apply for leave today. I think Miles answered that. We will have a considered opinion from council either today or tomorrow about how to reply with privacy. Is that correct, Miles?
With the privacy issues, yes, and whether that component of the direction is lawful. It may be that a pragmatic solution is the path forward if you're being withheld pay. We have really got to balance that threat of not being paid and the impact it could have on your families with the fact that we say it potentially is unlawful, or that request for information could give rise to other discrimination. So it might be that you choose to apply for leave simply because you're out of desperation. If that is the case, we would like to assist you with that leave application to make that clear about the coercive nature of why you are required to do it. So if you are in a situation where you feel you have no other options but to apply for leave, then it is really important that we interact with you on that point.
Bit of a curveball here. I've now been granted rec leave on compassionate grounds, i.e. not enough time to get the jab, so now you do. Does this rec leave have to be paid back if I take it and still don't get jabbed? So if they've given you leave to go and get jabbed, you don't get jabbed, you have to give it back.
The biggest risk you've got is if you have made a representation to your employer that they're going to grant you a certain amount of leave so you can go and do something and it was never your intention to do it, well, your employer might rightfully argue that you tricked them or it was somehow dishonest. And what ended up being a process where they are being potentially coercive and breaking the rules could turn back on you. So be very careful about that situation. If your employer is paying you to go off and get a jab and then you don't, that could have a different blowback than you might think. So let me reiterate, if you are not concerned about having the jab, don't have the jab. If you have got some concerns about your health and safety or concerns about potential exemptions, then you should exercise those concerns in good faith and honestly. But please, misleading your employer will get you into a bit of trouble.
I've got another question here. I have had no response yet from my workplace at the MARTA, so private hospital. In an email sent out, they stated they would not be allowed, that we would not be allowed on premise after September 30. I have night duty tonight and finish at 7 a.m. September 30. Should I go in tonight or not? As I have not received a response and I would be on premises technically on the 30th. The line manager has no idea what happens after the 30th. I'm still on the roster.
It does say after the 30th, which is consistent with the directive, by the way, not on the 30th. So and I don't want to get too tin tax, but it would sound like if the direction is after the 30th, it would appear that would cover that shift. But if you've got any concerns, you should be clarifying with your employer, and that question that you just placed to us, you should put to your line manager for just this one shift. Beyond that, I expect that MARTA will be dealing with it more fulsomely. We've had a number of correspondences with MARTA in the last week, so I expect something might come from them, but time will tell.
And it is obviously concerning that your line manager has no idea what's happening. So, if those concerns need to be escalated to your line manager, and if your line manager's manager doesn't have any idea of what's happening, then it needs to go, up the food chain until someone has an idea of what's going on. Can we call in sick, or what does it go if we are working on the 1st and 2nd of October? Well, obviously you wouldn't call in sick if you're not sick, and if you have a direction not to turn up to the workplace on the 1st, then you can't. But at all times we are obviously ready, willing and able to work, and can be directed at the drop of a hat to turn up to work should there be a chronic level of understaffing or acute level of understaffing, but we just need it's totally in Dr. John Wakefield's hands now. If he wants to have his pool of staff halved overnight, then that's totally up to him. Interesting comment here at the Gold Coast Health. It's 40% unvaccinated. Wow, that would be God, just a real travesty if that was allowed to happen. Those nurses were not allowed to turn up to work. I don't know how they would keep the lights on. I have also been rostered this weekend and have not been advised not to attend. Do I just turn up?
Again, we're stressing that you're ready, willing and able to work, and that we're asking questions about your work health and safety. And you can't, though, not follow a direction of your employer. So if you wanted to turn up, we should offer. If they say don't, then you must not. Right now, bear in mind, if you just take the simple concept of the risk assessment, which is that you're engineering at risk. We saw from the document yesterday from Dr. Wakefield that if you're applying for an exemption, it's up to a month. By definition, as that was sent without knowing how many people would apply for an exemption, this is not a risk assessment that where there is something imminent that's going to happen on the 1st of October. By definition, that month to consider it means that it's an arbitrary deadline, not anchored in a genuine imminent risk, where normally in a safety area, if something was to change and you know that risk is going to happen on that day, you must engineer it out on that day. So those fundamental principles of risk assessment would indicate that a hard deadline being applied in this way to those that aren't applying for an exemption but are exercising their concerns lawfully with relation to safety would be an unusual situation to create a disciplinary process in, and I expect would be very surprised if anyone did.
Contracted staff who sent both required forms for NPAA saying I'm willing to work. Queensland Health to still pay flat rate wage, or will it be leave without pay, as my manager has stated? Also, have been told that those who choose leave without pay will eventually be stood down. What are my rights?
It's a good question. It's the same question of different cohorts, whether you be casual, fixed term, agency staff, and that is that you're ready, willing and able to work. You're going through a good faith process with relation to either exemptions or consultation, and therefore that we say is in precedence and it ought not affect your pay. I saw a question there, is it just clinical environments that need consultation? No, everywhere. You know, the boss is meant to talk to you with relation to your safety, and they have imposed a new methodology they're saying is because of safety. Therefore, it required consultation, irrespective of whether you wear a white coat or a blue shirt.
I work for a private nursing agency between several public and private hospitals, and I've been advised by a text message that I have to have my first dose tomorrow in order to be able to work Queensland Health facilities. How do I respond? The response is you need to start doing the risk assessment process, asking for the risk assessment. Have you been consulted? Is there a workplace consultation group on workplace health and safety? Has the risk assessment been formed? You must start getting on that training, go to our website and fire off those questions.
And if you're that means you've got likely a private sector employer by the sounds of it. And so the additional processes are, what have they done to assess your work health and safety with their client, which is the various hospitals that you're otherwise engaged at. So your employer is responsible for your safety, but the business unit for when you're at your host employer is also responsible for your safety. So start with your existing employer and then deal with it. Now, it might be that an employer unilaterally says, I'm just not going to pay you, and that may create an underpayment claim or another form of industrial claim. So just because they're saying it is the case does not mean that it will hold up.
I'm on sick leave at the moment, not sure what to do, as I've not provided a reply with regards to risk assessment. What do? I don't want to call my line manager, it's very uncaring. Just keep escalating the process. As we said, go to the next stage. You know, keep requesting from your manager, and then if they haven't replied again, which is probably too late to ask them again, just ask your line managers and keep escalating that process as you go up, and you'll be sort of protecting your position there, I guess.
If you're on sick leave because of this process, then it might not be that's the right leave as well, by the way. Bear in mind, if you just if it's stressing you or whatever, of course you might need to access that leave, but your sick leave is there for when you are sick, for non-work related areas or for areas that are otherwise not covered by workers' compensation legislation. It's not as an alternative to a stand down process. So so if you are, just on that note, a number of people saying, should I take sick leave? As Jack said, if you're legitimately able, crook, yes, but this is not about, that's an asset for you for when you're sick, not because your boss is imposing rules on you that might not be lawful.
I'm going to send off my exemption form later today. However, I've been unable to get my hands on supporting documents. Should I still send in the exemption so it's on time?
Definitely, and I understand that some clinicians are taking some time. If you're going to apply for an exemption, I would recommend you do so before the cut-off time. Whether or not they say that it is in sufficient detail to be accepted as a base application, well, we can deal with that. But definitely, if you have any intention whatsoever, what the correspondence from Dr. Wakefield said was to alert your line manager in writing. So the very first thing to do if you are applying for an exemption is to let your boss know that you are intending to apply for an exemption and put what you've got in. If you are waiting on clinical advice or advice from your spiritual leader, then you can't get it because of that time. Ideally, try and have that appointment booked in advance, so at least you can say on your application as to when you're meeting that clinician or spiritual leader.
And I think that answers this next question. Do you have to have your priest to write it on a certain form? No, and I think as Miles said, you need to be very careful with what your spirit leader said. You know, the Pope has sanctioned it, for instance, in the Catholic Church, but I think there are certain archbishops in other states in Australia that haven't. Is that right, Miles? So I guess that's...
This is by no means a definitive position. I understand that in Tasmania, the Archbishop sought some exemptions for priests to be able to go into aged care facilities that didn't have, that were conscientious objecting to the jab. This is far as it's gone. So it's a whether that's the position of a particular church or archdiocese within it will depend on, that's the relationship with you and your spiritual leader. Don't flub it though. Don't make it up.
This question here, I'll be sending the completed form for NPAQ site and attaching my risk assessment. So it's a request for a risk assessment, not your own risk assessment, just putting that out there. Do I need to make contact with a response yet to my HR? Do I wait for you guys to respond? No, a lot of this process is automated. So the initial step is on you to send an email to your line manager. If they haven't heard back, escalate to your line manager's manager. The next step is to go onto our, and it's on our homepage, it shows the steps. The next step is there's a link to your logged in page and there'll be a COVID form. So if you fill out that COVID form, that will then fire off an email to you, which you need to fill in. And then once that's filled in, it'll give you the document that will go to your manager. And we will do that on your behalf if you can't do that. So all this process, I guess, can be done without speaking to us, although we will be speaking to you in formats like this where we can speak to a large number of you at once. I apologise, we do have a number of volunteers in here trying to answer questions. We've been onboarding staff. I think yesterday, we started with 1,000 unanswered inquiries and we finished with 1,300 yesterday, even though we had something like 20 people working on it, trying to get back to people. So we are being inundated. I am sorry for that. We are trying our best. These are the best formats to try and to contact with us, to make contact with us. But again, the process that you need to follow is all on the website. You don't need to speak to us, and it will be stepped out.
And to be clear on the reasoning for that is that if your boss returns a risk assessment and you're comfortable with it, that might be the beginning and end of it, right? It is, we're here to help you consult if you are uncomfortable with the materials that your boss has given you. So of course you are the appropriate person to receive the first one, and so that you can assess that on your own merits. And if you're happy with it, move on. If you're not, then you've got your support of your union.
With regards to temporary exemption for pregnancy that they released yesterday, are we ultimately trapping ourselves to get the vax post-maternity leave, as they have stated employees who are pregnant and are willing to be vaccinated at the conclusion of the pregnancy are encouraged to submit an exemption? Worried this is a trap.
Look, I would need to look at the form, but if it requires, so for example, there's one in New South Wales where if they are allowed to continue to work, but they must agree to Moderna when it comes in. I think it is, or no, sorry, Novavax when it comes in, and that was a condition of it. If it's as hard as that, you should go in with your eyes very wide open and cautious. If, however, it's saying that you are going to consider or are likely, that gives you time to then consult and continue that consultation process. If it forces a commitment, then we would like to advise you prior to you sending it out. If it is saying that you are likely, and then that gives us a chance to help you inform your view.
I've completed step 3. So does that mean you take over now, as I haven't heard anything? Yeah. Yes, we will. You've appointed us as your agent. That will be sent off, and each one of those forms that get sent off, they do need to engage with. They're obligated to engage with. And apologies, we are trying to clear that backlog. We have volunteers coming in to help out and manning computers. If you do want to volunteer, if you are in Brisbane, if you're around Bowen Hills, you're a nurse or another frontline professional who'd like to volunteer, please send us an email, because we can certainly use the help and we can put you to work, or just send through an email with in the subject line volunteer, or I think there's a Facebook post too calling for volunteers on the NPAQ Facebook page. If you make a post on that, we'll engage with you, and hopefully you can help us help more nurses. That's ultimately what we're here to try and do. A number of my colleagues and I have taken our first jab but feel 100% coerced. What actions should we take?
The direction for the obviously second jab is far more relevant, and if you have felt coerced but it's done, there may be a separate cause of action under different laws, including under human rights laws in Queensland about forced treatment and coercion, and that they have limitation dates from as little as unlikely 21, but up to 12 months. There is also a letter we can write to your employer, either that is consistent with the Human Rights Act, that they have then, I think it's 45 business days to reply to if those are the areas. But we can also then continue the risk assessment process. You don't have the hard deadline of the 30th at midnight, but that doesn't mean that you don't have other deadlines as well. So if you do feel your employer has coerced or forced you into experimental medical treatment, but then there are still some options you can take. But we also respect that some people have felt an enormous amount of pressure from very senior people and also from the regulator as well. So it is completely understandable that you took that first step. If you now would like to learn more and assess the risk assessment, that's also very, very fair. So it doesn't, in fact, you may have additional legal causes of action, but that's not for today. The most important thing is that you rationally assess your risk.
Miles, I understand you have a day job to get to, unfortunately, but thank you so much for your time. Look, I know there's a number of questions we haven't got to yet. We will be scraping the chat for any of those questions that are repeat questions coming up. We will be doing an FAQ and getting it out. So if you remember, please, look out in your emails because you'll be getting that FAQ. If you're not, please join and you can get it that way. We may even start putting it up on social media for those who have those questions as well. I would just like to make another point, and Miles will roll his eyes at this, but we do really want to be on a unity ticket here with the other trade unions, the big guys. They're the ones that have the big cash, and if we are united on this front, we are going to apply a hell of a lot of pressure, more pressure to the government. If I could just give you some stats, yesterday we had over 250 new members join us. That's $700 a pop every year that isn't going to the old union. So that's $175,000 per annum just yesterday that they've lost. It's getting somewhere in the vicinity of 1.5 million in the last 2 weeks. So surely if ethics and morality isn't driving the change of heart, then surely the bottom line will. So if you do want to try and apply more pressure, get more of your colleagues to join, and hopefully we can see some of the big players start to enter into the arena as well.
I guess to sort of echo or add to what Jack's saying is we're just so surprised that others have just said go along with it and not sat with you. And there are a lot of very, very tired people both in our office and over at Bowen Hills there, because everyone, these are genuine questions. They're good people asking legitimate questions that are not trying to resist for resistance sake. And if you and Deputy President Dean made that point yesterday, that these are very well considered people asking fair questions that are being attacked and targeted and being told there are no choices. And so while we were not expecting this last month to have the sheer volume, we're doing everything we can to help you during this time, and we'll support you any way we can. And that you deserve to be listened to and deserve to be consulted with.
I will just give a plug to our Telegram, which we post a little bit more sort of pointed advice on there and keep people up to date. So Tracy, our Telegram link is
t.me/NPAA001. You can type it.
I will type it in here. So that was
t.me
t.me/NPAA001. So if those of you who are familiar with Telegram, you can check us out. I think if you just search NPAA, we come up, and we'll be posting some of our media that we've done yesterday and today, and you can keep up the loop with that. So anyway, thank you very much, everyone, for joining in. I will say, if there are questions that you have and you haven't been answered, there is one more of these sessions this afternoon at 5 p.m. Same link, same details, just tune in at 5 p.m. And feel free to spread the message far and wide. I know we had about 300 participants on just then. I think we can get up to about 1,000 before it limits. So if we do get to the limit, then we'll have another one as well. So thank you very much, guys. Stay safe, and I understand it's a very stressful time.